Morning, good morning, good morning. Indeed, it is a wonderful morning. We thank you all for joining us here at the Strata webinar, Tuesday, March 28, 2023. This is an important date in all your diaries. So we just want to tell you thanks. So to the chairman, Mr. Andrew James, the CEO of the Real Estate Board and the Commissioner of Strata Corporations, Mr. Phillip Chambers, Director of the Commission of Strata Corporations, Inspectorate, Miss Tricia Harris, our Revenue Officer, Mr. Jermaine Sims, inspectors and other members of staff of the Commission of Strata Corporations, ladies and gentlemen, our most valuable stakeholders, we just want to tell you good morning and welcome to this, our webinar. So we thank you for being with us here this morning and for taking the time out of your very busy schedule. We truly appreciate it. I am Ainsworth Norton, Director, Timeshare and Manager of the Continued Professional Development here at the Real Estate Board, and I will be your moderator for this morning. Almost said this evening, but I do not intend that we'll be going into this evening. This morning, we have a very succinct agenda, one which should allow ample time for us not only to talk to you in great detail about the role of the Commission of Strata Corporations, but also to hear from you, our most valuable stakeholders. I'm going to invite our chairman, Mr. Andrew James, to bring greetings to you at this time and to set the stage for this morning's proceedings. Mr. Andrew James has been a real estate practitioner for almost 20 years. He is the managing director of A.S. James and Associates Limited, whose team of over 20 salesmen provide the full slate of real estate services, including sales and rentals, property management, and valuations. Mr. James holds membership in both local and international associations, including the Realtors Association of Jamaica, having served as a past president between 2019 and 2020, and the National Association of Realtors in the United States. He also holds international designations such as Certified International Property Specialist, and resort and second-hand home property specialists. He is also a past board member of the National Association of Realtors, NAR, which is in the United States of America. I present to you our esteemed chairman, Mr. Andrew James.
Thank you, Mr. Norton. Good morning, or moderator. To our CEO, Mr. Phillip Chambers. To our main presenter, Ms. Tricia Harris, inspectors of the Commission, Strata Corporation, other board members, members of staff, and of course, to you, ladies and gentlemen, good morning. It is my pleasure to bring greetings and add my words of welcome this morning. We know that your time is valuable, so we thank you for investing that time into being here with us today. Firstly, as I stated to our dealers and salesmen yesterday, I want to begin by welcoming our new Chief Executive Officer, who took the reins of the organization in January of this year. I believe this will be the first time many of you will be interacting with him. And as such, I use this opportunity to formally introduce to you Mr. Phillip Chambers. In our many meetings and discussions since he took office, and I think I can speak on behalf of my fellow board members in saying that I remain confident in his ability to articulate a vision for moving the organization forward in keeping with the dynamism and increasing complexities of strata living. The mandate of the Commission, as expressed in the Registration of Strata Titles Act, is to monitor and regulate operation of strata corporations. Regulation of strata living is not and was never intended to drive revenue or to extend the hand of government bureaucracy and overreach. Instead, it was born out of a realization that there was a situation in shared ownership that had become untenable based on the irresponsible and inconsiderate action of others. In an effort to correct this mischief, the Commission is and continues to be an important partner in the move to create harmonious living arrangement with Strata Corporation. Our existence is usually questioned, but this cannot be fairly done by the dozens, if not hundreds of persons who utilize our dispute resolution services, information and search services, meeting, assistance, annual return review, monitoring and audit functions on a yearly basis. Our Strata Corporation's Director, Ms. Tricia Harris, will come to us shortly and explain in greater details the extent to which we are confident in the fact that we do indeed provide much needed service to the public. So today, we want to also hear from you and share with you. While we cannot commit to taking on all recommendations and suggestions, we can commit to listening and considering all points of view. If time will not allow all issues to be adequately ventilated here and now, we remain available via phone and email beyond this session. It is my hope and belief that this exercise will result in positive, tangible outcomes for Strata Living. We thank you, and we look forward to the discussions to follow.
Thank you very, very much, Mr. James. You have done well to introduce what we will be addressing in this particular webinar. So now we'll divert our attention to our newly minted CEO, Mr. Phillip Chambers, to address you at this time. But first, let me tell you a little bit about Mr. Phillip Chambers. Mr. Chambers has been the Chief Executive Officer of the Real Estate Board, Commission of Strata Corporations, since January 2023. He has a wealth of experience in the areas of general project and personnel management within the maritime, aviation, and petroleum services, acquired during his tenure as General Manager of the Jamaica Aircraft Refueling Services Limited. He also has significant experience in government regulation and licensing, having served as Senior Director of Operations, Deputy CEO at the Cannabis Licensing Authority from 2021 to December 2022. He holds an MSc in International Public and Development Management and a BSc in General Management from the University of the West Indies, Mona. Ladies and gentlemen, our CEO, Mr. Phillip Chambers.
Our moderator, Mr. Ainsworth Norton, Chairman of the Commission of Strata Corporations, Mr. Andrew James, our main presenter and Director of the Commission of Strata Corporations, Inspectorate, Ms. Tricia Harris, Inspectors of the Commission of Strata Corporations, Board members, Directors, members of staff, ladies and gentlemen, good morning and welcome. I want to thank you wholeheartedly for taking the time to register and attend this morning's session. This to me is a clear indication that you are willing and open to listening and sharing, which allows both sides to learn from each other. Before I begin, I want to thank the Chairman, Mr. Andrew James, for his vote of confidence in his opening remarks, and by extension, the board at large. I also wish to thank my entire team for the support and encouragement they have given me in my brief period here. It has given me much confidence that we will be able to achieve meaningful change and growth, working together for the good of the industry. I hope any opposition to the following statement will be in the extreme minority, if not non-existent, when I say this organization is one that punches above its weight. Given the size of the various groups it regulates relative to our staff complement. On my first day, I articulated a vision for the organization to my management team, a vision which I'd like to share with you today. The vision is working collaboratively to achieve organizational excellence through continuous process reviews and updates. This forum, which is the second of 3, with various clients and professional working groups we serve, is a small but significant part of that collaborative approach. Organizational excellence, as I expressed then, will continue to be a goal of this organization, to be the very best version of ourselves, in spite of the human resource challenges we face. It is also an example, in spite of the human resource challenges we face, of the kind of open and transparent communication we intend to practice. In furtherance of that principle, we'll be launching our new merge website very soon, which will bring together information from the board, the Real Estate Board, the Commission of Strata Corporations, and the Real Estate Training Institute. In addition to that, we will continue to use our mass email platform to send timely reminders regarding our CPD courses, AML updates, deadlines, and a host of relevant information. We will also be launching a customer satisfaction survey very shortly to solicit your feedback across our various service areas. Some of you may also be contacted via telephone by the Consumer Affairs Commissions for additional information. I want to encourage you to share honestly and openly, as I am asking you to do today. We can only improve if we know what the gaps are, and those gaps are not always self-evident, but may differ based on one's perspective. This will not be the last of such sessions, but we will continue to use this medium intermittently as the need arises. Our chairman briefly mentioned some of the human resource adjustments which we have made recently with regards to improving our service. I would add, we would have reclassified some of the key positions, including managers of both inspectorates. We have added key posts, such as our human resource manager, and would have split a number of posts, including our facilities and procurement managers. We will also be recruiting in the near future for additional inspectors, with some of these inspectors to be assigned to our shared communities with the pending responsibility for gated communities. While some of these are purely internal, their impact will ripple through the service delivery of the entire industry. There are also physical changes to accommodate the changes we have made. For example, we have expanded and relocated both inspectorates on account of the growing complement of inspectors. The final vision I want to share with you is one of fairness and objectivity with regard to our processes. We will ensure that our processes are not only known, but carried out consistently without fear or prejudice. This will apply to all areas of service, not just our dispute resolution services. Ladies and gentlemen, strata living need not be fraught with contention and discord. On the contrary, if we are armed with the necessary information beforehand, there is no reason for persons not to abide by the pre-existing rules with due consideration for fellow proprietors. That same kind of respect and decency is what we expect to be shown as we ventilate the various issues and opinions this morning. As we transition closer to the question and answer portion of our program, thanks once again, and I trust my team of inspectors and managers will be able to answer your questions adequately. Thank you very much.
Thank you very, very much, Mr. Chambers. We would like to take this opportunity to acknowledge some key individuals on our panel that were inadvertently not mentioned before, but by no stretch of the imagination is their omission a perception of their importance. They are indeed quite valuable both to the board and the commission, as well as to the industry itself. I take the pleasure in introducing Mr. Howard Johnson Jr., board member of the Real Estate Board Commission of Strata Corporations, as well as Mr. Cresford Brown, who is the board's first and newly minted Chief Operations Officer. He's well known to the industry. He was formerly the manager of the Inspectorate for the Real Estate Board and would have interacted on a number of occasions with stakeholders. So we welcome you both, Mr. Howard Johnson Jr. and Mr. Cresford Brown. All right. Now we're going to move a little bit further into the meat of our sessions. And this morning, I will first like to invite Mr. Jermaine Sims, the Revenue Officer of the Commission of Strata Corporations. Many of you will be familiar with Mr. Sims as he served the organization as a customer service officer for quite a number of years. So Mr. Sims has been with the organization since 2014. Mr. Sims will speak to how we can avoid unverified payments, which have proved to be quite problematic for both practitioners and for us at the Real Estate Board Commission of Strata Corporations. So, ladies and gentlemen, please welcome Mr. Jermaine Sims.
All right, thank you, Mr. Norton, for the welcome. And I also want to thank everybody for joining us this morning to this session. This portion is one of importance, and no doubt it is of concern to us, and it's also of concern to you as well. And so let me just go ahead and share my screen here. Okay, so this morning we look forward to talking to you about the various payment options that is offered by the Commission of Strata Corporations. Now, this is not necessarily geared towards collections per se, as the payment methods, is almost as if we're sensitizing it because we want to collect, but not necessarily. Over the years, we've been having some challenges. And so it's good to have you in this medium now to be able to highlight these challenges to you so that we can be able to serve you in a better way. Now, on the agenda for this portion, we'll be talking about our mission, the payment options, as was mentioned, and a summary of what we would have discussed. Now, one of our mission is to create an effective model for regulating a real estate industry that ensures greater compliance of the industry, the professionals, while at the same time earning and maintaining the confidence of all stakeholders. Now, I wanted to focus on the latter part of our mission right here, earning and maintaining the confidence of all stakeholders. Now, you may be wondering, what does this have to do with the payment methods for this portion? Now, you have an obligation, a legal obligation to the Commission of the Strata Corporations to pay your yearly annual fees and your annual returns, as well as to submit your annual filings. And so part of our mission of earning your confidence is having accurate records. And having accurate records, not just of the documents that you submit, but also the hard-earned money that you pay to us. And over the years, the challenge we've been having is identifying the various methods, payments that persons have been making to us. So persons have been making lodgements to the Commission of Strata Corporations, and at times it's a challenge to know who these monies belong to. And it is a concern to the Commission of Strata Corporations. There are things that are happening behind the scenes that you would not be seeing. You'd be seeing the concern of the managers, of the CEOs, trying to figure out who these monies belong to, ensuring that these monies are properly accounted for. Because keeping in mind our mission, we want to earn your confidence and to maintain your confidence. So we want to ensure that when you make a payment to the Commission of Strata Corporation, it is properly accounted for. Right. So with that in mind, we have a number of avenues by which you can make payment to the Commission. Over the years, we have increased them. You can utilize the bill payment options. At this time, unfortunately, the bill payment option is limited to only Scotiabank and the NCB. So just for emphasis, that's bill payment strictly through Scotiabank or NCB. Of course, if you utilize other banks, then any other bank for that matter, the third-party transfer option is available to you as well. For those who feel more comfortable, we do accept in-office payments as well. And if it is that you prefer to actually go to the bank, you can actually go to the bank and make a lodgement to our accounts. Right. All right, sorry about that. All right, so the last option, fifth option, a bank deposit that you can utilize as well. Now, a view. We're just giving you a sample view as to what the payments look like when they come to the Commission. On screen, you'll notice the Scotia bill payment and the NCB bill payment option. Now, there are some key bits of information that is captured that is critical to us accounting properly for the monies that you have made paid to us. So for the Scotiabank, you'll notice the date. There's the name of the individual. As an example, there's the PSP number. There's a confirmation number by which we are able to use to track the payment, differentiate your payment from that of another strata, as well as the amount. Same principle. On the NCB side, you'll see the registration number. That's what NCB calls it, but in reality, that's your strata number. You'll see the amount, NCB's confirmation number, the date, and NCB, they actually capture the name of your strata. Now, this represents a proper payment. So once we get a payment like this, we're able to properly account for that payment, have it processed, receipted, and thereby entered on your statement. So whenever you request a statement, once we have all this information, we'll be able to provide you with accurate records. Now, on the other side now, if it is that you utilize the third-party option, this now represents a challenge that we have been having. Sometimes when you make a transfer to our accounts, this is the only thing that we see here. So let's go through it. So it comes to our accounts, we see the date, we know that it's a deposit, we see a confirmation number, and we see it's coming from John Brown, and we see the amount of money that was sent to us. But just you see the problem here. Who is John Brown? And what is John Brown paying for? A key bit of information that is missing here is the PSP number. When we get a transaction like this, regrettably, there is not much we can do. At times, we'll have the inspectors, we'll have the accounts department, we'll have discussions with the inspector just to confirm. Maybe yesterday they had spoken to John Brown. John Brown had promised that his strata will make a payment. And so, a particular inspector may recall speaking with a John Brown. But what if that didn't happen? So here lies the problem. When we have these fees, we are not able to properly account for these fees, and thereby it puts us in a difficult situation in order to maintain our mission as well as our obligation to you. On the other side, we see another example of a transfer. In some instances, John Brown makes a transfer to our accounts, but this time it has the PSP number. In this case, we're able to identify this one, right? And in some instances, when a transfer comes from certain institutions, those institutions spell out every bit of detail. So you'll see PSP, Strata plan, and by the time they spell out everything, they actually cut off the important bit of information, because how the banks do it, there's a set amount of characters that can hold in the space. So by the time they reach down to the section that is to capture your PSP number, that portion is actually cut off, and we're not able to identify that payment. And it really is a problem for us, and so which is why we're having this discussion this morning. Now, the payment options, again, just to go through them in a bit more detail. When you utilize the bill payment option through BNS or NCB, you're really just paying us like you would any other bill. So you pay your JPS bill through your bank account, you pay your water bill and so forth. They ask you for your premises number and so forth. The same principle applies using the bill payment option for these banks. The difference is they ask you for your PSP number. So this is the simplest way. Once you utilize this method, it captures your information and sends it over to us. The third-party transfer, our account number is listed here, and our account name. Sometimes persons actually go into the bank, they fill out they are lodging a check, so they utilize the Dropbox option. So when they make these deposits, sometimes they leave off some information, and that is on the other side of the bank deposit. So they may put on the CCP number here, they put on the account number, but they leave off the PSP number. Sometimes they put on the PSP number and they leave off the 16-digit CCP number, and then at times the bank is not able to complete that lodgement. Or if they do, sometimes we realize the banks actually try to accommodate you. And so they have realized that if it is that they just enter 4 digits, any 4 digits, the lodgement will actually go through. So sometimes on our records, when we see a deposit, it simply says, I like to see the CCP number, and simply puts 1, 2, 3. But we know there's no Strata 1, 2, 3 per se. So we wouldn't necessarily be able to readily identify that one and have that payment process. So we're encouraging you that whenever it is that you're utilizing the payment options, you ensure that the critical information is there. The account number, the name of your Strata, the Strata number, all that information is necessary. Of course, if you come into office, we by default will capture all that information. But because we want to offer you the convenience, we have broadened the payment options, but we are imploring you to actually fill out the necessary information so that we can continue to maintain our mission. Now, the other part of the payment option as well is the payment verification form. In recent times, we would have sent out emails to individuals about the payment verification form. This is in response to the challenges that we have been having. Some persons have actually responded, but what we realize is actually the persons who responded are actually persons who would have already had their payments responded. So we are encouraging you, once you make online payments or payments at the bank, fill out that payment verification form. The form, you can pick up a copy at the office. You can download it from the website as well, csc.gov.jm. Fill it out, whether you want to type it out or you simply want to do it in a handwritten way. The option is yours. That is very important in order for us to capture all the information so that we can have your payments processed in a timely manner. We don't want a situation whereby you request a statement from us, and when time we give you a statement, you're saying, but I noticed 3 years payment is missing from my statement. When in reality, it is missing, yes, but we are not able to capture and accurately identify that payment. And in reality, the money is there, it's in our accounts. but we are not able to credit that money to you. And we know you have the records. We know you have your receipts from the bank. We know you have your bank statements showing these transactions, but you have it. But guess what? We want to have it as well. So we're not saying that you're for every single transaction, you're going to flood our inboxes, but just go through your statements. You're able to see there are details on the statement. It shows you the type of transfer or bill payment that was used. So you're able to identify what payments you have made versus what payment is missing. So all that is there. Now, in summary, we're encouraging you to make payments using the necessary credentials, your Strata number, the name, completing the payment verification form, which is very, very important. If it is that you have difficulty with the form, send us an email. The email is very important. Whether you want to send us a copy of the deposit slip, your bank statement with the record of that transaction. This transaction is mine. It belongs to PSP such and such. All right. Additionally, as well, what we've also seen too is that sometimes we may have property managers. They perhaps managing multiple stratas, and so they may create a bill payment account and they use PSP 123, but they are going to make a payment now for PSP 321, but they use PSP 123's account information to pay for PSP 321. And so when that comes into us by default, it has all the necessary information. So we are going to credit that money to PSP 123. So we are encouraging you as well, in this case, ensure that your records reflect the strata that you are actually paying for, so that we can have, again, the information updated in a timely manner. We want to be confident that when you come to us and you request a statement, we want to be confident in sending out that statement to you. All right. So with that in mind, again, our email address, our website, csc.gov.jm. You're encouraged to visit that. A wealth of information is there. The forms are there for you to download as well. And our email address that you can actually send us these documents, it's info@reb.gov.jm. And additionally as well, there are individuals who would have spoken to the inspectors. You may have spoken to somebody from customer service, and so forth. And so once you make your payment, you may be inclined to say, even our legal officer, you may have spoken to them. And because of that, you make your payment and you send your payment directly to that individual. But by doing so, what do you think could happen? So if you spoke with somebody from customer service and you send your payment to that individual, suppose that individual is out on leave. What if that individual, for whatever reason, no longer works here? So we see the problem right there. So if it is that you spoke with that individual and you want them to know that you made that payment, you can still send your payment verification forms or proof of payment to the Commissioner of Strata Corporation's email address and copy the respective individual on that email. Once you send it to the Commission's email address, we have our IT department who actually goes through and filter these emails. So we are aware as to who may or may not be at work. So if you send that email, we will assign it to the next available officer so that your payments can be processed in a timely and efficient manner. So with that in mind, I trust my presentation has been informative. I trust the payment methods are clear. The importance of submitting proof of your payment so that we can maintain our records. We can earn your confidence, and not just earn it, but also maintain it. Thank you very much.
Thank you very, very much, Mr. Sims. Indeed, your presentation was as clear as crystal. But we ask individuals, if it is that you have any queries concerning payment options, any further queries, you may ask them in this forum, or you may also write to us utilizing our email systems to ensure that we communicate with you effectively and provide you with the kind of information that will best suit your purposes. I'm going to say what the email addresses are now, but in the in the coming presentations, and possibly at the end, I will provide you with the written email addresses in the chat. And you can address your concerns to RHD support at reb.gov.jm or through info@reb.gov.jm. All right. So thanks again, Mr. Sims. I too was also enlightened by your presentation. And now I will invite my colleague, Miss Tricia Harris, to take the baton for the final leg of the presentation relay. Miss Tricia Harris has over 20 years experience. Don't look at her young face, she is very experienced, in the management of large-scale commercial and residential property portfolios. As a director, Commissioner of Strata Corporation's Inspectorate, she leads the team responsible for monitoring and auditing the operations of Strata corporations. She holds a BA honors class from the University of Technology in Finance and Marketing, and is a certified property manager. That's a big thing. Hey, let's welcome Miss Tricia Harris as she goes through her presentation. Miss Harris.
Thank you very much, Mr. Norton, and good morning again to everyone. I would first like to take the opportunity to echo the welcome and the sentiments already expressed by our chairman, Mr. Andrew James, and our CEO, Mr. Phillip Chambers, and to thank the participants in this webinar. Now, for most of the real estate practitioners present, much of the information that the Commission will be providing today will be for reinforcement purposes, because you would have participated in a number of our public education exercises over the period of since 2010, since the inception of the Commission. But we feel the need to start from scratch again in terms of providing the data, because what the Commission has observed is that there has been a rapid and significant expansion in the number of new corporations in recent times. It would have come about, especially since the density provisions were amended. So therefore, because we have seen the increase in numbers, it follows therefore that there are many new proprietors, and by extension, many new executive committees that have been onboarded to Strata Living in the past few years. So the Commission's objective today is to provide a comprehensive overview of our services and our function in a concise manner within the allotted time. I will try to keep the time as we again continue in our efforts to fulfill our public education mandate. Now, from a practical standpoint, by the end of this session today, proprietors should have a better understanding. Those proprietors, especially the new ones that are present here, should have a better understanding of the legislative framework that governs their living environment. And with that improved understanding, we're hoping that it will foster or facilitate better landscape for our practitioners, which we don't want to forget, especially our property managers. So with that, I will proceed into my presentation. So the main content that we'll be reviewing today is who we are as at the Commission of Strata Corporations. What the case for the Commission, why it is that we are an important entity, especially in respect of the sharing of the living that involves the sharing of spaces in properties that are registered under the Registration Strata Titles Act. We look at our regulatory function, the services that we provide, or dispute resolution services. We issue certificates of pause of sale, the operations of the Strata Appeals Tribunal, status certificates, and how that service would benefit prospective purchasers. And that presentation, I'm anticipating, should take us up to 12 o'clock or as close to as possible. Now, who we are. The commission was established in 2010 under the Registration Strata Titles Act. But I just want to pause here for a minute because the legislation existed far, well, long before 2010. In fact, the original legislation was passed in 1969, and it was not amended until 2009. So that would have been 40 years since the original passage of the legislation. And the commission was operationalized in April 2010. And you can imagine in 40 years, and it was alluded to in our chairman's presentation, that there would have been some mischief that would have occurred during that period. And in fact, there are quite a few mischiefs that occurred during that period that would have triggered the establishment of a body set up specifically to regulate the affairs of strata corporations. What we observed is that within that 40-year period, there were several weaknesses that needed to be addressed. There were high levels of delinquencies that could only be recovered to the court. So the 2010 amendment sought to address these weaknesses. Another issue or mischief is that strata corporations weren't seen not to be convening their annual general meetings. The executive committees were also failing to provide financial reports to the proprietors. And in fact, that isn't the case where they had executive committees, because very few corporations, in fact, because they were not convening general meetings, they did not have valid executive committees. So all together, that environment was ripe for regulation. And as a result, the legislation was amended to address the issues of lack of accountability on both sides, both in respect of the proprietors themselves, as well as the lack of accountability from the executive committees, because they were not fulfilling the obligations that were set out even in those 1969 bylaws. And with the creation of the commission in 2010, a void was filled, because prior to the inception of the commission, it was an unregulated sort of Wild West environment. And so the commission really has come on board and filled that void called lack of regulation. And those are the two main issues that came out of that 2010 amendment: the creation of the commission and the strengthening of the legislation to ensure accountability on both the part of proprietors as well as the executive committee. The commission shares a CEO with the real estate board. We share the same physical location, and we are, as you are aware, we are under a merger, an ongoing merger with the real estate board. But currently, we do operate two functionally separate inspectorates. We're hoping that with the merger, we will create greater synergy between both inspectorates, because the development process really is one process. And we have observed that increasingly, because many of the new developments are strata corporations, you really have a relay between that is run first by the real estate board inspectors and then picked up by the strata inspectors and soon to be the shared communities inspectors as well. So that's basically the relationship, the structure between the board and the commission. Our primary functions, because we are, and it's cliche now to say it, but it is true, we are a creature, the commission is a creature of statutes created under and by virtue of the Registration Strata Titles Act. Our main objective, our mandate, is to monitor, regulate, and supervise corporations. And as we proceed into the presentation, you'll get some insight as to how it is that we carry out those duties. We also maintain a register of corporations, facilitate dispute resolutions, because again, this was one of the main areas of weaknesses in the 1969 legislation. If you had a dispute, you had to go to court. But then there were other, the court system itself is clogged, and there are other issues that may not necessarily lend themselves for where persons are living together and they may not necessarily want to take a very litigious approach. So the dispute resolution mandate really was created to sort of create that balance. It is helpful in that it is speedy. It has its advantages, which we'll go into later on in the presentation. But if you look at the spirit of what is outlined here, at the end of the day, parties are in contention, but at the end of the process, both sides have to go back and reside within the same community. They are neighbors. So we needed a process that was focused on resolving the issue while healing the breaches. And we found over the years that many of the matters that have come before the commission actually have, though they present themselves as breaches under the act, a lot of them have underlying personal issues. So that is basically what this mandate is speaking to. We also have the responsibility to consider complaints from proprietors regarding the levy of contribution, whether it is unreasonable or inequitable, and our general directive is to enforce the bylaws. So in service of its, well, my apologies. As I pointed out earlier, one of the commission's main objectives is to monitor and regulate. And those are the policing aspects of our work. We also have a softer target, a softer mandate. We provide proprietors with the necessary information and guidance, similar to what we're doing now on this platform. And we advise proprietors of their responsibilities, as well as executive members, as well as practitioners. Once you're engaged with Strata Properties, the commission is available to provide guidance as it relates to the act, not legal advice. And that's a distinction that I wish to make here. As alluded before, we provide an avenue for proprietors to resolve disagreements, because sometimes the disagreements are not clearly just breaches of statute or breaches of bylaws, but there are other underlying issues. We conduct ongoing reviews and assessment of affairs of Strata Corporation. That is part of our policing effort and our enforcement activity, which again, that will be further fleshed out in the presentation. And again, just to reiterate here that we maintain a registry for those corporations that are newly registered. So once the development is completed and the splinter titles are issued, and the registrar of titles assigns a strata plan number within 90 days of that registration. All corporations are required to register with the Commission of Strata Corporations. So the registrar of titles will assign a PSP number, that's your incorporation, but the commission will assign you a CSC number. To date, there are around 2,100 corporations incorporated in Jamaica. So the main crux of our target, which is monitoring, regulating, and supervising. And this is really a significant mandate because this is the teeth of the commission. We do not always wish to bite, but in order for us to be effective as a regulatory body, we have to have teeth. We have to have force of the law that will bring the parties subject to the legislation into compliance. And we carry out this monitoring, regulation, and supervisory role through two main proactive methods. And I just want to rest here and just point out that the commission is quite proactive in carrying out its functions. We are not a body that sits back and waits for complaints. If you look at section 3, it says that we resolve complaints, but we are not waiting for persons to come and tell us what is wrong. The commission has an aggressive program of conducting monitoring inspections, as well as reviewing annual returns, requesting and reviewing the annual returns that all corporations are required to file with the commission on an annual basis. So these review processes involve working with the strata corporations to identify deficiencies. And I know that sometimes when our inspectors are on ground, especially executive committee members may feel tentative, and because they see the assessment as pointing to deficiencies, which would then later be revealed to the body corporate. But that is not the primary objective. Yes, having identified the deficiencies, that is where our work begins. Because ultimately, what we want is to bring the corporation into full compliance. And so we anticipate collaboration between the proprietors, the executive committees, and the commission to work for the benefit of the respective corporations. So let's look at the review areas. When you see our inspectors visiting your strata on a biennial basis, that is every other year, each strata corporation is subject to a monitoring inspection. Because of the numbers that I just pointed out, about 2,100, we are not able to inspect you each year. It is hoped that once we follow through the process, in the period of inspection, you will continue, you will make improvements as property managers and proprietors. You will continue, you will abide by the guidance that is given or the notice is received, and you will make the adjustments and improvements to build on the suggestions, so that when we return the year after, you would be in a better stead than we found you in the first place. So I just want to point out at this juncture the issues that the commission, or the areas that we assess for, because it's good for you to know beforehand so you can prepare for your reviews. So the first thing we look at is general meetings, whether or not they are convened annually and whether they are valid. Now, the legislation provides, and especially the bylaws specifically, provide that each corporation is to convene its general meeting annually. However, there is an additional 3 months grace period. So the legislation actually says that not more than 15 months should pass between general meetings. So once our inspectors are on ground, we're going to be looking to see if it is that you're having your meetings, and we'll also assess for the validity, because it's not just sufficient that you have meetings, but that those meetings be valid, and that any fruit flowing from those meetings, any resolutions, any budgets that are passed, any decisions that are made are valid. So in testing the validity, we're looking at the statutory compliance of the notice of the meeting. We're looking to see whether the notice was, whether 14 clear days notice of the time and place was given. In reviewing the annual returns, we have found that persons are not counting the 14 days properly. So if it is that we are serving a notice on the 1st of April, the meeting should not be held on the 14th, because that's not 14 clear days. The meeting should be held on the 15th of April. So unfortunately, in our reviews, we have picked up on this as an issue. And it is unfortunate because sometimes this is the only issue that is preventing the corporation from being compliant, because you would have attempted to convene a general meeting, but when we put the notice to the test, it fails, and therefore, from our perspective, the meeting is invalidated, and everything that flows from it is also invalidated. Another area that we test for is quorum, because yes, the notice document can be in order, but you have not established a proper quorum of the meeting. Now, it is, you basically, without a quorum, the corporation would have basically met in vain if it proceeded to business, because, and a quorum, just to reinforce, is 1/2 of the paid up proprietors. So to this end, what the commission has suggested and what we're checking for is that you maintain a register of proprietors in attendance at the meeting, and that prior to the day of the meeting, you begin to compile your list of balances, because if it is that we are proceeding with our meeting on the 15th of April, on that morning, the property manager or the treasurer or any member of the executive committee is charged with that responsibility should have a listing as at the 15th of April of the balances of every single proprietor. From that, we'll be able to establish who is paid up, who is not, and therefore how many paid up proprietors would constitute a quorum. Often when the commission checks at this point, because we would be behind the curve, the meeting would have gone already, what we're finding is that persons are still misunderstanding the concept of quorum. So I'm appealing to the property managers to give proper guidance to your strata clients, and to be a stickler on this matter of quorum. I'm also asking the treasurers of the executive committees to not be swayed by proprietors who have outstanding balances and are seeking to contest the balances at the date or on the morning of the meeting. Once you would have sent out your notices, the statements of account, and the proprietors are aware, if they wish to vote at the general meeting, they simply can pay the balance stated on the statement to put themselves instead in a proper place where they're able to exercise their vote, and then they can complain to the commission. And so the point is that you need to comply in order to exercise your vote and complain. But you have, proprietors have the right to protest, but you do not have the right to vote if it is that you have a balance on your statement as at the date of the meeting. We're also checking to see if the resolutions were properly passed and recorded in the minutes. There is a Strata management course, it's a CPD, and if you have not yet participated in it, I'm encouraging you to do so, because that course goes into details in how resolutions are to be properly structured and recorded in the minutes. Very often the resolutions are ambiguous, and even after our inspectors have reviewed the minutes, they're not quite sure what decision the corporation would have made. And it really defeats the purpose, because it creates discord if it is that your resolutions are not worded with clarity. We are also checking for the apportionment, the proper apportionment of contributions. Now, even if proprietors think it is the apportionment by statute is unit entitlement only, and even where proprietors think that the apportionment is inequitable, the only legal method of apportioning contributions, whether maintenance, assessments, levies, is by unit entitlement. I recall having a conversation with two members of an executive committee a couple of weeks ago, and they seem to be searching the legislation for gaps to see if they could contest the apportionment. Now, if you look at the section, it says that the corporate, it uses the word shall in terms of apportionment, shall by that the contributions shall be apportioned by unit entitlement, and shall is prescriptive. Property managers, please understand that there is no going around this, and executive committees as well, please understand, there's only one way to apportion maintenance and contributions. I don't just want to say maintenance, because the legislation actually speaks to contributions, which is, it includes far more than just maintenance. Any of the charges that you're levying, those should be apportioned by unit entitlement. So once our inspectors verify that you're in breach, we'll explain what will follow. But once we verify that you are in breach, ultimately, you are going to be instructed to recalculate. We're also checking to see that an executive committee is in place and elected within the past 15 months. In some cases, we have gone on site and we have seen persons representing themselves to be the executive committee. And when we query, when was the last time they had a general meeting, they're saying to us, oh, it's a couple of years now, we have not met. This is an issue. It flows from the whole issue of not having your general meetings in a timely fashion, but it's more, it is why we look specifically at the committee is because of the statutory duty imposed. The committee is the body that exercises the powers and the duties of the corporation, and it can be detrimental when a committee takes certain action, enforces the bylaws within the context of the corporation, serves notices on proprietors, and the issue of their jurisdiction comes into play, and then that matter is elevated to the commission. It complicates matters unnecessarily. It is, I think it is quite simple if that proprietors convene their meetings in a timely manner and that persons volunteer. I understand that persons are shying away from from being elected to the executive committee because of the amount of work that is involved. But I think it's less work to be on an executive committee than to be in a situation, in a quagmire where there is no clear management structure. And if it is that you are, for example, to do a transaction with the bank and the bank wants verification of your outstanding balance, and there's no one who is legally eligible to certify the amounts outstanding, to untangle yourself out of that process, I think is much more taxing and onerous than serving on the committee. I think proprietors need to understand the trade-offs. Spending a certain number of hours per week engage in the management of your own asset, to my mind, is a better way to spend your time than having to deal with the issues at the back end, because we have seen it at the commission many times. Persons want to close a sale, and because there's no committee in place, it really creates an entanglement in the process. So so we look specifically at the validity of the executive committee and when they were elected and the jurisdiction of the committee. We also assess for insurance, whether it is that the corporation has purchased the insurance required under Section 5, or if it is that they have passed a unanimous resolution to do otherwise, which is inclusive of a resolution to not insure. We also assess whether there are outstanding annual returns. And if we take our minds back to the original, well, my introduction, when we spoke about the mischief that would have triggered the creation of the commission, one of the issues that pointed out was that executive committees, excuse me, sorry, that executive committees were failing to provide financial reports. They were failing to be accountable financially to the body corporate. Now, we'll go in detail in this presentation into what are the components of the annual returns. But once the inspectors are on site, they would have already researched your files and they would have known all of the reports outstanding. They are there, one, to notify you that you have reports outstanding. You have financial reports outstanding to the commission, as well as reports on your activities. But they're also there to find out the underlying issues. What would have caused you to fail to submit your annual returns? Sometimes sometimes an executive committee is in place, but we have cases of infighting where, in one instance that I know of, the treasurer may be withholding information from the other executive members. We have cases where there is no executive committee. It's one person who is handling the accounts, and there's no segregation of duties. So once we're on site, we are not there to ask you whether or not you have filed, because we already know. We are there to find out why you haven't, and we are interested in taking steps to ensure that you have filed. When we get into the detail of the annual returns, you'll understand how far or how far the commission will go to pursue recovery of these annual reports, because they shed a lot of light as to what is happening, especially when you're dealing with the handling of finances. The failure to submit your annual reports is a red flag. It says to the commission, please come and audit me because there is something amiss. So I really want to point out to the proprietors and the property managers present that it is imperative that all outstanding reports be submitted. We're also looking at whether there is a receptacle for service. It's really just a letterbox labeled PSP number, and the PSP number that is affixed to the front of the complex. It serves two purposes. One, it's for identification. As we drive around, sometimes we're able to even identify strata, that a property is a strata plan, because they have the receptacle and we know the PSP number. It's very easily identifiable. The other benefit, of course, and the primary benefit of the receptacle is that it is an instrument put there for the receipt of service. We're also looking as to whether there's any disposition of the common property and that the disposition was done properly. We know that corporations are usually looking for additional means of income. So they may rent part of the common property. They may, some strata corporations have units that they have converted to apartments. Some have sections of the outer property that they have leased for billboard rentals. And what we are looking at is whether there was a unanimous resolution to dispose, to lease. There are cases where corporations have actually sold parts of their common property. And we're in the case where it is the government of Jamaica that has imposed that as the transfer as eminent domain, there is an allowance, because if the government says that they're buying back a section of your property, whether you agree or you disagree, it won't stop that process. What we're looking at in terms of sale especially is where proprietors have extended into the common area. They would have built into the common area, and how that is treated, because if once you're in a strata property and you extend outside of your strata lot into the common area, you begin to tread on the ownership rights of other persons, because remember, the common property is held as tenants in common. So it doesn't belong exclusively to any specific proprietor. So I can't say because this section of the common area is behind me and nobody else really walks there, then I can just extend into it. So those are the issues that we're looking at under item 7. We're also looking at breaches in general within the physical property. Sometimes there are objects mostly in the form of laid up vehicles. We have had cases where persons are actually operating car mart out of the common property. We have had cases of animals. There's one we know where a pig farm is being kept in the common property. So we're looking at those things. Those are the extreme cases, but from time to time, we do have applications before us to deal with the removal of objects and animals from the common property. But before, as I explained to you, the monitoring and supervision is a proactive portion where the commission is not waiting for you to come and tell us that there's a problem. We are going on site to ferret out the issues and to try and resolve them before they escalate. So in addition to the monitoring inspection, which is that on-site review, the other part of our monitoring and supervisory role is our review of the annual returns. And it's gonna be a recurring theme. And the review of those documents will tend to alert the commission to certain administrative deficiencies, as we have pointed out before. Now, in looking at the annual returns, we're reviewing all of the areas that are covered in the monitoring inspection, except for physical breaches in the bylaws, because so whether it is a review on paper or it is a physical review, remember, as I had explained, the physical review is every other year, but the annual returns, because you would have been required by statute to file each year, there's gonna be a review on paper. So we should not be missing any issues, whether by paper or by our physical visits. We should be capturing all of the issues and any deficiencies, any defects. The only difference is that because the annual return is a paper review, we're not gonna pick up the physical breaches there. If it is so that having reviewed your returns, you are deemed to be in order from when we assess for the statutory requirements, that application will automatically trigger a physical inspection. So we'll go on ground to confirm whether there are any physical breaches, because clearly you would have been in good, on paper, you seem to be in good stead, but we need to come and verify for ourselves before we give you our compliance certificate. So again, the annual returns, it's all the areas covered in the monitoring inspection, except the physical breaches, but it goes a little bit deeper in respect of the accounts, because as you recall, this is the provision that the legislators would have crafted to treat with the failure of the executive committees to report on the financials of the corporation. So when we look at the accounts, we are looking at consistency between the financials and what would have occurred in the general meeting. Just as an example, if it is that we look at the income statement and we're seeing rental income, but then when we check the minutes, we are not seeing the resolution for the unanimous resolution approving that rental, we're gonna write you and ask, since it is not in this minutes, you need to give us some additional details. When was the approval given for this property? When did the lease commence? And we need further details before we'll assess you as compliant. So the returns looks at the general statute, but then it goes deeper into an analysis of the financials of the corporation. We have seen financials that, and I don't want to disclose too much here, but we have seen some troubling financials. And in looking at your documents, we're also assessing the effectiveness of management, because when we look at your receivables as a percentage of the annual charges, it says to us there is a problem. And all of that would be pointed out in our letters to you and our follow-up action. As I pointed out, if the various areas are satisfied, then both from the monitoring inspection, which is the physical side of the physical review, as well as the annual returns, which is the documentation review, the commission will issue a certificate of compliance for that specific financial year, for that review period. So come the 1st of April, if it is that you have been filing your returns over the period, we should begin to receive those reports for the 2022-2023 period. That's April 2022 to March 2023 period. And so these, and of course, sometimes you're not assessed as compliant on the first go. It's a rigorous review, and you'll find that we'll get back to you and ask for additional information. Do not feel disheartened when you're asked for additional information. Yes, it is more work, but it means therefore that there is a possibility of us designating you as compliant. When we assess and we write back to you and simply say you are non-compliant, it means that for that financial year, you're basically dead in the water. You have no chance of redemption until the subsequent period. What would cause that? So for example, if it is that we have done our assessment and we have found that the general meeting is invalid, you can't go back and convene a general meeting in the prior financial year. So on that basis, you're just non-compliant. There's nothing that we can do except to point out where you made your mistakes and suggest and support you in not repeating them in the upcoming period. So we're now at the regulatory part of our job, because you would have seen how they through the monitoring inspections, as well as the review of the annual returns, we would have done our monitoring and supervisory functions. But then here comes the teeth, because if it is that you are not in compliance, it is the commission's job to enforce the law. There's no other way to say it. That is our job. We are a regulator, and having whether it is the monitoring inspection or it is the review of the returns, this is what you would have noticed over time. So I'm just going to explain what these steps mean. Step one is soft. After the monitoring inspection is completed, you would have gotten a 30-day reminder letter outlining all of the breaches. Whether it is that you're not using entitlement, or you would have failed to file your returns, or you're not insured, whatever the breaches are as observed, we would start off by sending you a 30-day letter. That gives you an opportunity to make the corrections. If it is that all issues cannot be resolved within the 30-day period, you can write back to us. You can say, I'm working on some, those will be completed within this prescribed time. However, I'm requesting an extension. The commission is prepared to work with its stakeholders. If it is possible that you're able to resolve all of the issues within the 30 days, then we can assess to see whether you can be deemed compliant. If not, as I said, we'll just at that point, if it is that you're working but you're not going to be able to be compliant within the period, we'll grant some extension, and will not elevate to step 2. So my suggestion is that you work with us, you engage with us on receipt of that 30-day reminder letter. If you don't, then we move to step 2, which is a 30-day notice. And many of you would have seen those non-compliance notices. What those well, again, it means that you have I would say it's another grace period to it's an additional 30-day grace period to remedy the outstanding issues, remedy the breaches. Because if that notice signals the beginning of the beginning of the enforcement process, because on the expiration of the notice, we will immediately move to legal action. So if it is that you have gotten the soft reminder and you have not complied, and you have gotten the notice, I would suggest that you comply, because what is coming next is more detrimental. Because at that point, we're going to take it to court. And even, for example, where corporations have failed to file their annual returns, we have started taking those corporations to the Supreme Court. And we have been successful in getting declarations. And at that, it is informative that corporations that would have failed to respond to the soft approach, would have failed to respond to the medium level approach, somehow become very amenable when they're sitting in front of a judge at the Supreme Court. And they're more than willing to comply, and more than willing to find all of the outstanding financials, because now they understand that that detriment is in play. Even in respect of our initial registrations, you'll notice that the commission is shifting its focus. Initially, we would have sent just a letter. Once it is that you would have been registered, you would have gotten your strata plan number from the Registrar of Titles. We would have sent you a letter telling you about the commission, telling you about your obligations, and inviting you to register. I think maybe in the past, maybe over the past 18 months to 2 years, we have not been sending the reminder letter. We have just jumped to step 2, which is a notice. So for new corporations, what you're actually getting is the notice. So you'll get a 30-day notice advising you of your obligations. Then it will be followed up by a further 15-day notice reminding you of your obligations. And at that point, we move to step 3. So it is unfortunate, but the commission has been around now for over a decade. And we have always done our routine public education exercises. It is necessary. We find it necessary, especially given that Jamaica has a context, a social context of non-compliance. We find it necessary to be more assertive in our enforcement mechanisms. Where we would have found in the past that persons were willing to comply, the developers, the proprietors were willing to comply. We find even with the initial registration, I remember in the very early days when the commission sent out those letters inviting voluntary compliance, within short order, within the first year, we were able to get up to around 80% compliance in registration, and that was voluntary. Now we're looking at the new registrations, and for the current period, we are not finding that we're getting the level of engagement without just jumping to the medium approach, which is the 30-day notice. So if you're managing a strata, or if you live in a strata and you see those notices posted, whether on your gate, on your fence, please do not ignore them. Reach out to the commission and engage with us so that we can have you have the matters sorted out and we can give you guidance. I think our objective really is to have cooperation, collaboration, voluntary compliance. But if it is that we're not going to receive that, we have no choice. We have to step up and enforce and to prosecute. Now I'm going to going to the requirements for filing annual returns. So under section 47 of the Registration Strata Titles Act, all corporations are required to file returns within 120 days of the 31st of March. As I pointed out before, we're coming up to that point in the year. We're less than a week out. So property managers and treasurers should be getting their documents ready to submit to us. Persons complain about the documents and the work, but just to point out that the returns serve the best interests of the corporation because it assists us in flagging potential problems. As I said before, it's the potential. It is our means of flagging the potential problems and taking early corrective action. I've been notified that I am to move along more quickly. So I'm just going to speed it up a little. So the annual returns includes Form 8, the audited financials, or Forms 13, A, B, and C. Those are available on our website. And they should be signed by the chairman of the corporation and at least one executive member. The notice of the AGMs, EGMs, the minutes of the general meeting, the receivables listing, and I had explained before why the receivables listing is important, because it's going to give us the opportunity to test for quorum. We need the updated address form, we need the certificate of insurance, or the resolution, the unanimous resolution to not insure. We need a budget and 3 random proprietor statements. Why? Because again, we're testing for unit entitlement, and we need the photograph of the receptacle. All of these, let me just go back. All of those requirements are set out in our annual return checklist that will be provided in your package. I know we sent, there was a package sent earlier this month. However, we are redoing it because the data was not up to date, it wasn't current, and we're redoing it to send out to you this week. So you will get this information in your annual returns packages. Dispute resolution service, again, as we pointed out, it's to facilitate the resolution of disputes arising under the act, and the process is really an alternative to the court. So instead of going to the court to seek relief for issues arising under the act, you can simply come to the commission. The applications a complete application includes Form 10, payment of the application fee. It's a fee per complaint and not a fee per form, which means that persons write 10 different complaints on one form and pay a single application fee. It's a fee per complaint, and you also submit your supporting documents. Some of the advantages of the dispute resolution process are cost. I mean, the cost of the application is far below what it would cost you to if it is that you work to go to the court, and you may have to procure legal representation. So we believe that the dispute resolution is advantageous in terms of cost, in terms of time, again, because the matters are disposed of more quickly than in the civil court. And of course, another advantage is the quality of the facilities. We provide air-conditioned offices. It's a comfortable environment. And one of the advantages, again, is that from the facilities is that when you go to court, even though you may get a 10 o'clock date, you're in line. When you get a 10 o'clock time, when you get a date and a 10 o'clock scheduled hearing at the commission, you are first in line. You're the only one in line because that's your specific designated time, and we are ready to proceed. So those are some of the advantages of our process. Some examples of disputes that have come before the commission. In the cases where it is a corporation that is launching the complaint, some of the errors are breaches of bylaws, non-payment of maintenance, illegal construction and removal of pets and derelict items. Oftentimes, though, it is the residents that are launching the complaints, and their issues related to failure to convene general meetings, improper calculations of contributions, notice of the meetings, all of those things that relate to the responsibility of the executive committee. You'll see that those are the issues that are raised by the corporation. Again, this is why the legislation was amended in 2010 to create the commission to handle these matters instead of going to the court. Some of the successful outcomes that have been provided by the commission involve recovery of outstanding maintenance fees, removal of laid up vehicles and water tanks, and restoration of the common property. We have issued orders for restoration of structures and the common property, that is the removal of structures. Sometimes it's extensions or changes to the patio. But one of the big benefits of this resolution is the recovery of outstanding fees. And I know a lot of executives and managers use it as a very efficient process of recovering hundreds of thousands of dollars per strata corporation. The commission is not one-sided, and I know proprietors may think, oh, we are here to represent the corporation. No, we are here on the side of the statute. If we have a bias, it's a bias towards the statute because we are bound by the legislation. So in the same way that the corporations have come to the commission and they have been successful in their complaints, there are times when they are not so, when they are unsuccessful, and it is the proprietor whose complaint has been validated because we have issued orders for recalculation of maintenance fees. So if the proprietor says, listen, they're not charging me, they're not apportioning my maintenance by unit entitlement, and the commission looks at it and it's found to be true because we test the complaint against the legislation, then the commission has we have no latitude. We must rule in favor of what the legislation says, which is unit entitlement. We have given orders invalidating improper general meetings, and we have vacated the resolutions because all of the fruits from an improper general meeting would have to be cast aside. The orders, we have given orders for the corporation to consider maintenance expenses at general meetings, where the corporation has refused. It has an obligation to maintain and to repair the common property, yet the corporation is refusing to even consider the expenses. The commission has issued orders to say, listen, this item needs to be put on the general meeting for the consideration of the body corporate, and with the understanding that it is a statutory obligation for the body corporate to maintain and repair common property. And we have also issued orders permitting proprietors to inspect the books of accounts, quite a few of those. Our commitment in respect of these services for continuous improvement in service delivery. We're always, again, per our CEO's statement, we're always looking to improve our processes to make them more efficient, and hopefully in short order, you'll begin to see even more changes in respect of this service. The power of sale, again, this is another critical service because it's going to help those to address those high delinquencies. And for this point, I just want to rest on the 30 days. Where if it is that the proprietor is 30 days outstanding, the corporation shall apply for the certificate of power of sale. It's not an application that is dependent on quantum of arrears, but of the time the arrears has been outstanding. And once you pass that 30-day threshold, so as proprietors understand, once you pass that 30-day threshold, the corporation can apply to the commission for the power of sale, and the commission is bound to review and process the application based on its merit. And the advantage of the power of sale is that it is significant in disincentivizing persons from withholding maintenance. So if you have a dispute with the corporation, You should not withhold the maintenance because you begin to put your property in jeopardy once you are withholding for in excess of 30 days, because there's no defense under the statute for withholding maintenance fees. The requirements for the power of sale, Form 9, that's straightforward. Notice, what are we checking for at the commission? The name and the address appearing on the notice is to be the same as the title. So for example, we have seen notices that say John Brown, because everybody knows that the proprietor's name is John Brown. Yet still, when we have asked for the certified copy of the title and look at it, the person's name is Jonathan Brown, but they're using the diminutive. Please pull the certified copy of the title before you submit your application, because it means that you have to do over the entire notice and start the process from scratch, because John Brown is not the proprietor. He wouldn't have served the proprietor as required under the statute. We're also looking at that the notice states the amount of interest. It must be clear, and it must be the same as in the statement. Same for the period of arrears. The period in the statement cannot be different from the period that is in the cover notice letter, because together the notice and the statement form the letter, and the statement form notice to the proprietor. And the notice itself must inform the proprietor of their right of appeal to the tribunal. We also we're looking at whether you have proper proof of service, registered mail, if it is delivered by mail, that you have the photograph of the notice on the door if you're serving at the property, and a copy of the certified title. So the main areas of defective submissions, and it pains us because very often we have quite a number of applications that we can't issue certificates so because they're not in order. Why? Again, proprietors are failing to use, not proprietors, committees are failing to use unit entitlement. They are failing to charge, to have the charges levied in the statement approved at the general meeting. So all of those issues that we would have looked at from our inspection and our annual returns, if you pay attention there and you address it at that time, it puts you in good stead when it is that you come to the commission for a certificate of power of sale, because we're not sending you back to get all of these corrected, or we are not bouncing your application and saying you are not in a state where you can successfully obtain a certificate. We're also looking at the statement of account. It must start from a zero balance. I know what we have seen is that persons start at a zero balance, but then they have an accumulated brought forward balance. And what they have done is to transfer it from the top of the statement and bury it further down. Where not because we say you must start from a zero balance means that we're just going to look at the beginning of the statement. It's a thorough check. So wherever in the document you bury your brought forward balance, we're going to find it, and on that basis we're going to bounce the application. So we require start from a zero balance. We require individual invoices and payments over the period. We ask that all charges must be apportioned by unit entitlement. And we also ask for approval, the submission of the approval of the charges, which is evidenced by the minutes of your AGMs and EGMs. I won't stay long here. The appeals tribunal, it's basically, it is a separate entity from the commission. It's actually higher than the commission, and all the commission, proprietors and executive committee, we all have the right of appeal to the tribunal, and because it has discretion, it cannot allow an appeal or it can set aside you can dismiss the appeal. It even has the power to vary or set aside the decisions of the commission. So when you're filing your appeal, you are to file them at the commission's offices. I know a lot of persons tend to ask, they've been asking, where's the tribunal located? It's an ad hoc tribunal. Its office though is at the commission at 24 Trafalgar Road. So if you file your documents here, they will reach to the tribunal. Decisions of the tribunal, they are binding on all parties. And so if it is at the tribunal issues an order and you do not comply, you will be guilty of an offense and liable to a fine not exceeding $1 million Jamaican dollars on conviction before the parish court. In terms of how to file your documents, because the tribunal is separate, they have their own gazetted rules that govern the entire appeals process. I invite you to look at our website. It's listed on the screen, and which will tell you what are the documents that comprise a notice, how to serve, when to serve, the whole procedure for the hearing. All of that is in the gazetted rules. And remember, because it is gazetted, it is a notice to the world. Therefore, there should be no reason for proprietors or practitioners to say they don't know where to get the information from, and they were never told before, because it's gazetted one, and the commission has also published the gazetted notice, the gazetted rules on our website. The status certificate, that's another service, provides relevant data on our strata corporations and prospective purchasers. That is relevant for prospective purchasers because it will help them in making informed decision. Years ago, the commission realized that we had a number of persons buying into stratas, and they say, you know, I regret the decision because if I had known all of these problems when I was buying, I would not have purchased. And so that spurred us to create a product to assist prospective purchasers in their buying decision. It is not to be treated as a guide. All it does is to give the purchasers more information to within their own due diligence process to make better decisions. In the same way that you would query your outstanding water bills or your property taxes, it's a means of querying whether the strata that you're intending to buy into has issues, whether there are complaints, the number of complaints that have been launched against it, the appeals. It gives information on the percentage delinquency, which is an indication of whether or not it has proper management. So it's a useful tool, and I invite the practitioners to encourage the purchasers to look at the status certificate, because it's not a guide to say you must or you should not buy. What it does is to simply give you additional information so that your clients become informed buyers. And then this slide basically just repeats what I had pointed out. These are some of the issues that are tracked on this certificate, and it's available from the commission. I think the fee is between $1,000 to $1,500, and it's available within 5 business days. Of course, you can search our registry. That's one of the primary rules. We maintain a register of all strata corporations. You can get information as to whether the strata is registered. If there's an executive committee, the address of the complex, all of that information, and it's usually available for a nominal fee within 3 working days. And so I thank you for giving us this opportunity to again inform and educate the commission. Yes, we are an authority, we are the arbiter, we are the source of verified information, but from what you would have seen in this presentation, we also want to be your partner in improving the value of your asset, and that's one of the primary roles that we wish to fulfill. And if needs be, unfortunately, if we have to enforce, we will enforce, because we can't partner with you to your detriment and ours. Both of us must be seen to be effective in achieving our desired outcomes. So, ladies and gentlemen, I thank you for your participation in the workshop. I'll turn over to you, Mr. Norton. Thank you very much.
Thank you very, very much, Ms. Harris, for thought-provoking discourse on the Commission of Strata Corporations and the services that we provide. I do know from the comments that are written in the chat or the questions that are posed in the chat that persons will want to understand a little bit more of some of these issues. And so right now we're going into that question and answer segment. So we'll now be diving into that most important element of this session. And so this is where you are valued participants or most valued clients. You get an opportunity to field your questions to our capable list of panelists, to our capable panelists, all right? So that you can get the kind of responses that will adequately address your concerns. So we ask that as best as possible and as far as possible with you, that your questions relate to specifically to strata related matters and to what has been presented, and not of matters personal or otherwise, all right? So we don't want to be dealing with questions that relate to matters that may be before the commission, or personal matters that may or may not come before the commission. So we wanted to curtail your questions to what has already been presented and to issues that specifically relate to strata corporations. So we'll be taking questions from those in attendance with responses from our CEO or chairman, the presenters. And we also have a capable team of inspectors as well as our legal officer, Mr. O'Shane Vassiana, on hand to address your queries. I know we have quite a few real estate salesmen in attendance today who may have issues unrelated to this session, but we do crave your cooperation in curtailing those questions to what has been presented or to issues relating to strata corporations. So we'll be taking questions both in writing, those that have been posted in the chat, as well as for individuals who have indicated by the raised hand feature that is there. We'll try to alternate between both. And as far as possible, we want to address all the concerns. However, if it is that we are unable to address all the concerns before the close of the session, you will be invited to send your concerns to us via email, and the email address will be posted shortly in the chat for you to be able to respond directly. All right. So thank you very much for your cooperation in this matter. And we'll now go directly to the questions that have been posted in the chat. All right. So the first question is coming from Audrey Jones. And the question is that Andre Jones, Andrey? What about dealing with misappropriation with strata account funds? What is the process to start resolving that kind of issue? I'm directing this to the panelists. So I think Tricia can adequately address this as well, or any of the other panelists who, because they are quite capable of addressing these matters.
Okay, thanks, Mr. Norton. I think I'll take this one. In respect of the issue of misappropriation, we need to be very careful because it could be that it's a criminal matter. And if it is, in that instance, it's certainly beyond the scope of the commission. So the issue of misappropriation is very dicey. Sometimes proprietors complain and they coach the complaint using very strong language. If it is that there is a discrepancy, and let me take it down to that level, if there's a discrepancy in relation to the strata funds and you wish to have the commission do an investigation, of course, that is within our remit. You can, the proprietor can gather the documentation that supports the claim, because he who alleges must prove. It is not for proprietors to make a statement and then for the commission to as the arbiter, to seek to be investigating and to prove on its own. The proprietors, any proprietor making such an allegation should at least have some level of credible evidence to present before the commission in order for us to commit resources behind it. So let us assume that there's a discrepancy and there is some evidence. The commission has the authority to investigate and to audit. The audit is not a forensic audit, but we can do a statutory review to see if the processes are if the internal processes governing the management of the accounts are consistent with generally accepted accounting principles. If they are not, then we can take, or there's certainly, we have statutory powers to deal with that. So that's one way. So they can bring the information in either for us to do an investigation based on the evidence, or if it is that they are seeking additional clarity to say whether or not there is whether or not there is evidence for the matter to be dealt with further as misappropriation, they can come to us under the dispute resolution arm, because if it is that there are documents that they are not privy to, but it's a suspicion, again, proprietors have the right to review the records, the books of accounts of the strata, and that can be facilitated at dispute resolution. But it is we have to be very careful when we use a certain terminology, because the commission has to be very sure that it is not being weaponized. If you come to us, you should have evidence. If it is that you're seeking to review to better inform your perspective, then I would suggest you come as you apply for dispute resolution, review the accounts. You have the authority to review it yourself, or to have a competent representative review it with you, and you can form your conclusions as to whether, if it is a misappropriation, you would have some evidence to take to the relevant authorities.
Well, thank you very, very much, Ms. Harris. There's another question here from Carrie Lynn Johnson, and it reads, in 2023, there is still a requirement that every strata must have a mailbox located at the front of the property. This is not a real possibility in certain areas of Jamaica. Does the commission have any plans to have this requirement removed? I would definitely love for Mr. Bassiana to address that one, if he's available online just now. Yes, Mr. Bassiana, can you please?
No, thank you, Mr. Norton. Well, we certainly appreciate the view of the stakeholders, but I think a sufficient basis to start in answering this question is that this is a legal requirement. This is something that is entrenched in the law. This is an obligation which you have until the law changes. If that is to happen, then it is something that you must do, simply. Of course, if stakeholder consultation shows that perhaps our practical realities don't support a call for such a state of affairs, then of course our legislature is in a position where it can move with the movements of the general society. But as it stands now, what obtains is that receptacle must be there, and it must have the proprietor strata plan number on it. And for my own purpose, it serves well not only the commission, but the proprietors, in that, as we know, the proprietor strata plans are all corporations. One way for a corporation to receive or to get served with important documentation is by virtue of that receptacle. Outside of that, what may happen is a situation where when serving the proprietor's strata plan, number 1, for example, you have to go to look for an individual unit owner or some person authorized to accept service on behalf of the strata. So the simple answer to that question is that the law says the receptacle must be there and must be installed. Until that position changes, we have to respect the legal position.
Oh, thank you very, very much, Mr. Vassiana, because not only have you indicated the legal position that is there, but you have also given us the reason why it is there, you know, for receiving any sort of documents on behalf of the Strata Corporation, which is in fact an individual in and of itself, a legal entity. So thank you very, very much, Mr. Vassiana, for clearing that up for us. We move on to the next question. And this is from Flavia Ware. Why is the CSC requiring proprietors to be unanimous reinsurance rather than majority? This is unrealistic, and many small stratas are having issues with this, as proprietors say they can't afford to pay due to job layoffs, reduced income, old age, reduced pension, etc. This is an extremely loaded question, and I can see a couple of the panelists loading up to answer it, but I'm going to defer it to the panelists. Anyone can chime in and address this particular matter.
All right, I'll take it. And I'm going to ask Mr. Vassiana to provide some support. Let me give some historical context, because again, this provision has been on the books since 1969. And at the point when the legislation went to review in 2010, the very issue of whether or not to retain the requirement for unanimous resolution to opt out of insurance was put on the table and considered in the parliament. And what they had decided is that because of the impact on the proprietary interests of each proprietor, that as a result, each owner should have a say as to whether or not they want to insure their, they want to have collective insurance. Under the regulations, there is provision, well, the statute provides for an opt-out, and the regulations, as Mr. Vassiana, I guess, will speak to, provide for alternatives. But in speaking to strata insurance, especially for reconstruction, and that is the purpose of it, you know, for the for the reconstruction of the property, the question that arose, if it is that at the time was, if it is that this is my main residence, my only residence, and it is destroyed, and we are not going to be able to and I'm saying we are not going to be, we are opting out of purchasing insurance to rebuild, then every single proprietor should have a say, and I should have a say in that decision. If you look at the construction of strata properties, it's a completely different creature from a standalone unit that is affixed to the ground, because those properties that are on the first floor can't be reconstructed unless those properties that are on the ground floor are first reconstructed. Because if you look at the name, the Registration Strata Titles Act, it means the registration of stacked titles, layered titles. It means title up on top of title. Because of the implications on those individual proprietary interests, the Parliament at the time decided, listen, we are going to retain the provision and everybody should have a say. So that is why that is why the legal requirement is still there for the unanimous resolution for there to be a unanimous resolution for you to opt out. The provision does go on to say, unless the proprietors can unanimously agree otherwise. But I'm going to defer to Mr. Vassiano to shed some light on the nuances related to that aspect of the 1969 regulations.
Thank you, Ms. Harris. I think I'll start by saying that we must put the provision in context. And the context is this. As a unit owner, you have perhaps made the biggest investment you will make in your lifetime. Having made that investment, the possibility exists by some act of God or by some act of the universe for you to lose that investment based on a particular event happening. If it is you are called upon to make a decision as to whether you want to guard against the loss of that investment, it is certainly not something that you can place in the hands of somebody else, because this is your investment. And so in that context, the provision is there to ensure that all unit owners, all proprietors have a voice in the corporation's decision to insure or not to insure. But at the end of the day, the decision which is made must be one in which the input of all proprietors are present. The provision as it is worded has somewhat of a nuance. It says, unless the corporation otherwise determines. And so we have had questions fairly recently about whether the provision only allows a binary choice to insure or not to insure, or whether there is the possibility of you insuring for an amount which is not the market value of the actual building. Now, our own legal research in our department, looking at other jurisdictions, have told us that the way the provision is worded, it does not give credence to the conclusion that it's just a binary choice. The fact that it is stated, unless otherwise determined, it opens the door for the proprietors having the unanimity required to say that we want to insure for X dollars, even though we know that the building, the market value for the building itself is X dollars. And that also underscores the importance of the voices going towards the ultimate decision. And once we understand that, I think the question of unanimity will fairly be an academic discussion having regard to the practical realities.
All right, thank you very, very much, Ms. Harris and Mr. Vassiano for that response. I just want to remind participants that we have the raise hand feature, that if you want to voice your questions, you can do so as soon as we acknowledge you after you have raised your hand, all right? There's another question here from Rachel Harrison. What if the strata had no previous financials, or you are unable to get the information from the previous manager?
Is that for me, Mr. Norton?
Well, I would have wanted our senior inspector audit, Miss Scott, to address that matter. Is she on? Consider that she deals with a lot of the financial issues for Strata corporations. If she's not on, then of course you can address it, Miss Harris.
Hi, good afternoon. I'm here. Thank you, Mr. Norton. Good
Yes.
afternoon, everyone. So the question is, what if the Strata Corporation had no previous financial, or you're unable to get the information from the previous manager? Well, the Inspectorate, we are charged with assisting the Strata Corporation in what we call reconstructing the books of accounts. So what we ask is that the current executive do some legwork, background checks to see what the Strata corporations, the proprietors, were paying for their contributions for the specific period. We ask also that they do some investigation to determine what they used to pay in the past expenses for light, water, if it is that they have gardeners, you know, the routine expenses, if it is that they can get those information, get the data together, and we will meet with them and reconstruct. What we want is to get an idea as to what it costs the Strata Corporation to run the Strata for that particular period, and on average, what the maintenance income would have been. And the reason for this as well is because there are instances when our partners, other stakeholders, for example, mortgagees, they would want to issue a mortgage for a particular Strata corporation and would want to know what the maintenance for a particular year was, you know. So we assist with the reconstruction of the books of accounts. All right.
Thank you very, very much.
Mr. Norton.
Yes, indeed.
Yes, if I may add to that, this is Howard.
Please do. Please
There
do.
was an element of the question that spoke to what if you're unable to get it from a previous property manager? And I just wanted to, on behalf of the commission, indicate that the managers ought to have a license issued by the real estate board to enable them to practice in the area of property management. And therefore, there would be requirements for that property manager under law, under the Real Estate Dealers and Developers Act, to account. And the contracts of those managers should be with the Strata Corporation, thus having the manager liable to the Strata as a whole, as a body corporate and not an individual, not the developer. It is a contract with the Strata. So if you're unable to get the information, if they do exist, there would be a remedy under the Act for compliance by a licensed practitioner.
Thank you very, very much, Mr. Johnson. I was actually looking out to hear your perspective on these issues as well. So your intervention here is timely and well received, sir. All right, we will be going to the next question. And it is from Flavia Ware, and it relates to the proper disposition of common property. And the question goes, so Strata managers can rent out the Strata's common property? Example for accommodation, please clarify. This is very interesting. I know that would be very interesting. Anyone of you can tackle this one?
I'll take it, Mr. Norton, because I think there's a misunderstanding of the presentation. It's the executive, it's the corporation, actually, the body corporate that can rent the common property. Doesn't have to be an accommodation, as I pointed out. It could be a space, a section that they would have rented out for, let us say, a billboard. The The proper disposition means that the corporation would have convened a general meeting and that the proprietors would have unanimously agreed to rent or to lease or to issue a license in respect of the common area. The property managers are creatures of instruction. Therefore, if it is that their role would only be in respect of the administrative aspect of putting together the agreement and advising the committee along with the legal advice that the corporation would certainly need to procure in the creation of a lease agreement. But what was stated in the presentation is not that the manager can, but the corporation can, and the corporation would issue that directive to the executive committee, and the executive committee, which instructs the property manager, could give in directive for the manager to go ahead and arrange for the lease agreement. But no manager can act on their own to lease or to treat with the common property, because they act solely on instruction. So so to clarify, it is the corporation that would lease. And we have actually seen instances where there are units that are common units, they are not titled. And I don't want to mention any specific strata, but what the PSB has done is to finish off these units and they rent them, but those income streams go directly to the corporation, not any individual proprietor. They are funds for the benefit of the corporation. So I hope that clarifies the points.
Well, it certainly clarifies it for me, and I sincerely hope that it would have also been equally qualified or answered for those individuals who are so interested in that specific question. All right, we can take a few more questions, but we are going to be closing shortly. So unfortunately, we won't be able to get through to all the questions that are here that we know are so valuable. And I have left a link in the chat for you to be able to write to the commission with your questions. All right, we have another question here from Miss Claudia Forbes, and it asks, are there any remedies available to penalize proprietors who do not contribute to cess payments? Understandably, with no payment of maintenance, common area privileges are withdrawn. However, what can an executive committee do in the event of non-payment of cess? Tricia.
I'm going to step up to the plate again. All right. So, quite simply, for the presentation, there are two routes available. One, all right, let me just back up. Remember, I said, that the legislation speaks to contributions, regardless of whether it is deemed maintenance payments, assessments, or levies. The legislation permits the corporation to apply to the Commission for dispute resolution to recover outstanding contributions. It also permits the corporation to apply for a certificate of power of sale. In respect of the withdrawing of services, I'm not aware that is permissible. And certainly I'm going to bounce that part of the question to Mr. Vastiana. But from our perspective, what the commission endorses is A, bringing the matter before us for dispute resolution, or B, bringing the matter before us for an application of certificate of power of sale. But I wouldn't want to leave the whole issue of withdrawing services alone without having Mr. Vastiana comment on it.
Thank you, Mr. Harris. With your leave, Mr. Norton, I will just address that portion. The the issue of withholding services, because maintenance or contributions have not been paid, is one without legal authority. The statute is very clear as to what should obtain where contributions are not paid. And it gives you a plethora of options. You can come to the commission. The commission is ready and willing to assist you in the recovery of these contributions. Outside of the commission, though, the contributions can actually be recovered as a civil debt. That's one option. The other option also is that the legislation makes provision for, by order of a court, though, you could get possession of the particular unit. You can rent that unit out, and you can apply those amounts which you received from the rental towards the outstanding contributions. And if there is anything left, you hold that amount in an escrow account, for example, for the benefit of the proprietor Untitled. And so certainly I'm saying this without offering legal advice to the stakeholders as a whole, but just for general information purposes. We discourage the withholding of facilities and so on, because of the non-payment of contributions. If it is contributions or outstanding, please use the legal avenues which are afforded to you, so as not to put yourself in a situation where you would have acted in contravention of the legal requirements.
Oh, thank you very much. Mr. Johnson, you wanted to address the issue?
Yes, just seeing that we have our legal expert on the line as well, and it's something that I know is plaguing many stratas currently, just by virtue of how the new developments are built and what NWC is classifying as not giving individual water supply to each unit, depending on the levels or the floors, the amount of floor that are in a strata. And therefore, they bring supply to the strata, and the strata owns its own meters that they read and bill or charge or levy the usage or to the proprietors. And in that case, Mr. Bastiana, just provoking and it relevant to this question is whether or not the strata itself, who owns the meters and who gets one bill coming to the corporation, and a proprietor is delinquent, whether or not that supply can be disrupted by virtue of the disconnection of the meter that it owns, so that there's no further impact on the amount that is charged by the National Water Commission that affects all.
Mr. Johnson, this is a very important question. I must tell you, very important question. I will start by saying that the issue which is the subject of this question is an issue which is before our Court of Appeal, and my department certainly awaits a conclusive decision from the Court of Appeal on this. I will call it the bulk meter issue. And so at this juncture, I would not wish to express a position on it, as it is before the court. It is before the Court of Appeal. But what I could do is I could undertake to make that decision publicly available by virtue of our website when we get the decision from the Court of Appeal. But in the interim, I could say that we are bordering now on the provisions of the National Water Commission Act and so on. So we have to tread very, very carefully. But again, I would say that if there is an issue which the Act adequately addresses in respect of contributions or anything else, you are at liberty as the corporation or the proprietors to utilize our dispute resolution service as far as possible, so that in the interim some relief can be obtained by you.
Oh, thank you very, very much, Mr. Bassiana, for that. We're just gonna allow for one last question. Unfortunately, and quite regrettably, we will not be able to facilitate more questions beyond the one that we are going to do now. Just ask that you utilize the email facilities to send us your queries and your concerns, and we promise that we'll be able to provide you with a response in a very timely manner. All right. So we're going to that one last question, and it is from Dwyneth McLaughlin. And I'm going to ask you to unmute your microphone and to just provide us with your questions or your concern.
Good afternoon, everyone. My question comes back to this thing about the unanimous resolution for insurance. Does this mean, well, all the proprietors, let's say we have 20, every proprietor has to be at that meeting or participate in that meeting, whether you have it face-to-face, virtual, or mixed? And if they don't, then what happens? Because we do have a case where one proprietor is deceased and the proprietor's name is still on the title. There are proprietors who absolutely refuse to participate. So what we will be doing is having general meetings on to no end, so as to come to a decision. What do we do in that situation?
I'm going to ask Mr. Bassiana if he would just address that specific thing.
Yes, thank you for that question. There is a facility available where a particular proprietor, for whatever reason, remains absent from meetings which require unanimity. The possibility exists for a person to be appointed so that unanimity can be achieved. So if it is a particular corporation has that problem, I hear in the particular facts leading up to this question that there is an issue with a proprietor who is deceased. Of course, you know, there are laws dealing with that. But to address it very pointedly, I will say that certainly the commission, and in certain circumstances, the court can appoint a person where it is a decision is needed of all of the proprietors collectively by virtue of a unanimous resolution, and a person who is a proprietor is absent for whatever reason or is continuously absent from those meetings, then that unanimity can be achieved by virtue of an appointment.
Well, thank you very, very much, Mr. Bassiana. And ladies and gentlemen, we have to leave it right there. Can't go any further. The recording for this session will be made available to you via YouTube, and the link will be shared via email. All right, we are trying to take note of your queries, and we do hope that you will respond to us via email to give us those questions that are so dear to you, and we will be sure to address them as quickly as we possibly can. So thank you, our attendees and presenters and our panelists. Please do enjoy the rest of your day. God bless you.